Hearing none, let's move on to pretrial release. And Councilmember Guidry gets to say whatever she wants on behalf of the DA because he's not here, so just like Calvin Johnson.
I'm loving this. Okay. Now, actually, I wish I would have known that the DA was not going to be here. I didn't get a word on that, and I have prepared and worked on the pretrial services part of it, and of course, he has a diversion program, and so I reviewed his part of the report, but he would really need to present on his diversion program. So today I can present on the pretrial services portion of it. And we, the DA and I, given that there is presently no program, my office led the charge on research for the pretrial services program, but the DA's office has had input in it too, so I believe I can speak for him as well. We fully support implementing the pretrial services program in the criminal district court. The primary goal of the pretrial services is to identify those defendants who can be safely released from jail while their case is pending, that they are not a risk to public safety or a flight risk. The pretrial services programs are becoming increasingly popular in municipalities across the nation because they have consistently shown that they can save cities significant amounts of money by reducing jail populations without compromising public safety. Looking here in New Orleans, even just releasing those detainees who are presently being held on municipal misdemeanor and traffic charges would save the city more than 400 jail beds and nearly $3.5 million per year. That's calculated at approximately 414 inmates at $22.39 per day, 365 days in the year. So we're looking at significant savings for our city. And then if we looked at releasing prisoners, again, using the pretrial services risk assessment tool, held on non-violent felony charges, that would create even additional savings. The process, after a person is arrested and booked, a representative meets with the defendant and asks the detainee, the defendant, a set of predetermined objective questions designed to elicit information about that person's flight risk and risk to public safety. Address, job status, family ties, community ties, prior convictions, those types of things. The answers are then independently verified by the pretrial services personnel by, for instance, phone calls to employers, discussions with family members, checking responses against conviction records, etc. The verified answers are then incorporated into a risk assessment model, which produces a score for each defendant, very objective kind of thing. Based on the score, the representative of the program then makes a recommendation to the magistrate or judge at first appearance whether to hold the person in prison, release them with conditions such as ankle bracelet monitoring, drug, alcohol testing, and or treatment, counseling, or release with no conditions. And of course, the commissioner or magistrate retains discretion whether to follow the release recommendation of the pretrial services representative. If the defendant is released, then the program assumes responsibility for maintaining communication with the defendant to remind them of any continuing obligations such as future court appearances, drug testing, counseling, etc. We believe that the pretrial services program will create little to no public safety risk because the recommendation on release will be based substantially on an objective assessment of each defendant's risk of committing additional crimes while released. These are questions that have been tested in many jurisdictions over many years, thereby ensuring that they will provide information that has been proven to be reliable and effective in predicting whether a person is flight risk or risk to public safety. Under the current system, a person is released based on their ability to pay a bond, which is not a predictor at all of their their, possibility of committing additional crimes. And also, based on the gut feeling and experience of the judge, which is very informative, of course, but more information can only help a judge be more certain about their decision. Let's see. Our research suggests that the city can operate an effective pretrial services program on a relatively limited budget. You know, we had someone from DC come and talk about the federal program here, one of our first working group meetings. And that was a federally funded program to the tune of $45 million per year. Just absolutely unimaginable. And I think that was probably a bad beginning for us in terms of that we all looked at each other and said, this is impossible. But actually, Oklahoma City has a pretrial services program that makes recommendations on release for more than 13,000 defendants a year, with a total of 8 persons staffing it and a budget of $650,000. So this is within our reach, and the Vera Institute has, I believe, looked at the possibility of maybe a cost of $500,000 annually. Budget constraints may necessitate that some defendants be automatically excluded from consideration for pretrial release. I know murder defendants, I think by law, are precluded. But other than that, everyone else could be released if they can pay a bond. It is national best practice among pretrial service agencies to interview all arrestees, regardless of the charges against them, because, first of all, there may be mitigating circumstances in an individual case that are not readily apparent from the police report. And basically, again, the more information that you have, the more it will assist the judge. Also help in indigency determinations. I know that juvenile court has been operating a very successful pretrial release program for the past 2 years. It has a success rate of greater than 90% as far as people showing up for trial dates and not reoffending during the time that they are out. And it has helped to reduce the average daily population of the youth study center from 50 people per day to 23 people per day. The Vera Institute of Justice is presently working to implement pretrial services, a preliminary program that we're hoping will be carried on into the future. And I've asked John Wool to come here and talk for a minute about that, because they are working on implementation of this program now. There's a pretrial services working group that is meeting monthly and is comprised of representatives from the Criminal District Court, Sheriff's Office, District Attorney's Office, Orleans Public Defender, New Orleans Police Department, Mayor's Office, and the City Council. We are going to be, I am going to be advocating for the city to take up funding for this program upon the completion of the initial implementation phase that Vera Institute is going to implement with a federal grant. And it's all right with you. I'd like for John to speak to that a little bit.
So that's a great overview of
Pre-joint stand-up, John.
Sure. That's a great overview of pretrial services programs generally. As Councilmember Guidry says, they've been successfully implemented for decades now. Frankly, it's the 50th year from 50th anniversary of the first program in Manhattan. And then locally, just to say, which is frankly, just to reiterate, this is a tried and true approach that jurisdictions have seen benefit from for many years. We're not trying anything particularly new, but it is new for New Orleans. It's a very different principle underlying the detention release decision, moving away from, as Councilmember Guidry said, setting a money bond and seeing what happens, to inquiring much more carefully about the objective factors that can be linked in this community to whether people return to court as required and whether people commit new crimes if they are indeed released. And so we'll be basing this on evidence collected, data collected throughout the process, comparing it to a baseline set of data, what we now know. The working group, Councilmember Guidry said Vera is proceeding with this, but really important to note that, frankly, it's the people around this table and their key delegates who are working closely in a working group and just looking around so that Commissioner Carter has staff who come to the meetings and report back. Michael Bradley is the representative from the Public Defender Office. Deputy Chief Judge Buras is one of 3 judicial representatives from the Criminal District Court bench. The sheriff has Chief Hunter as well as Colonel Urson who come. Councilmember Clarkson and Guidry send staffers to the meeting. The superintendent sends one of the 2 deputy chiefs and or their staff. So we have the participation, and we've done this in a number of different areas. The participation in this group, the sustained participation has been very, very strong. And that's been important because we want to build a program that works here in Orleans Parish. It's not a great innovation, so we don't have to test new theories, but we do have to build something that works here, that fits in nicely with the good parts of the criminal justice system, and that attends to some of the weaker links in the system. So we've met now 9 times. We'll meet later this week for the 10th time. And we are sort of going through a checklist of all of the key pieces that will enable us to begin implementing a comprehensive program beginning mid to late fall, early winter this year. Pretty much on target, I think, for maybe even ahead of target in some respects. We still have a number of issues that need to be resolved, not surprisingly and not dishearteningly. We're moving through them, and I'm happy to answer any specific questions, but that sort of program that the council member and district attorney described in their report is what we're trying to help the criminal justice actors build for this community.
But in terms of funding, you all have a startup grant to help us get started. It's not an operating grant. That's why the councilmember indicated a budget request in the midst of her presentation.
It is both a development, there are funds both to develop the program, which is the phase we're in now, and some operating funds. So, and it looks like at this point, the grant proposal had us cut that at about the 12-month mark and the final 6 months. So we would have had about 6 months of operating funds. I think we're making good enough progress that we'll have closer to 9 months. I'm hopeful that we'll have closer to 9 months of operating, which of course, if the city chooses, and I certainly hope they do, to sustain the program once these grant funds run out, and that's certainly the theory, they will only have to do so in the next year for less than half the year, 3 to 6 months of the year. But that's where we stand now. And that's all funds from a federal grant, although we also have been developing this program for quite a long time. This is one of the principal initiatives laid out in the Criminal Justice Leadership Alliance formative document that Councilmember Carter, at the time Councilmember Carter, put together and convened in the fall of 2007. So we've had the support of local and national foundations to do some of the initial development.
And you're saying that we will need to be looking at budgeting for part of this in 2012 budget year.
Right.
So we need to hook in through the mayor's office while you all are putting together your budget. How do we do that?
Just did. So, I mean, somebody needs to send me a request.
I mean,
So it can
does
go.
it have to go to a particular department?
It would actually go to our public safety results team. chaired by Deputy Mayor Sneed,
Okay.
and he's evaluating all the public safety budget requests as part of the team in preparation of presenting something to the mayor. Then, of course, the mayor will hand it off to you all, and you will get to
Right.
put your imprint on it.
And I've learned our part of it. Okay, all right, so we need to get, your institute and myself.
Yeah.
Okay, thank you.
Good, Chair.
Couple of things. Number one, when you talk about Councilmember Goodry, and it's a common thing to confuse beds and inmates. And you talked about beds in your pretrial services, say more than 400 jail beds, and then you go down to say about 414 inmates. Jail beds, and I gave a presentation early on that clearly demonstrated, and I think even Dr. Austin backed that up, that clearly beds and inmates aren't the same because you need to have more beds than you have inmates. So I just point that out, that's a little point there to look at.
So that wouldn't affect the calculation in terms of savings, which mean is that because of flows in incoming
There's a number of things.
detainees,
There's
there's
flows,
seasonal or...
there's things like protective custody.
Right.
There's gender classification, there's criminal offense classification, there's a number of things.
Right,
that
so
affect-
you're not charged for a bed, though, you're charged for per diem for the inmates, so you're counting inmates, not beds.
Well, you count both of them each way. That's why I say you can't do both at the same time. Either you're gonna be consistent and say inmates, or you're gonna be consistent and say beds.
So
But you
it
can't
would
go
be
back and
inmates,
forth.
right?
Well,
Yeah, so we should change that to inmates, thank you.
All right. Secondly, it seems, and I'm not sure about this, but I read in your own research that successful pretrial services are also operated by the courts, by the district attorney's office, mayor's office, nonprofit, and sheriff's offices. Is there a predetermined result here that it's not going to be operated by any of those agencies, but by another agency to be created, like another bureaucracy, or is that something that's still under consideration?
Right, that is one of a number of issues that
And
need
when is
to
that
be
going to be
determined.
Should
You
it
know,
be a public
when
thing,
we,
or?
well, I don't know that that'll be determined in this working group, but if you all want there to be a recommendation on that, then we'll undertake that.
It's an issue that I brought up before I meet with John, the working group, because certainly we as judges want to know who's making a recommendation to us. You know, I was a prosecutor for 12 years, I've been a judge for 12 years, and I don't need someone that has absolutely no experience with criminal history, how to read a rap sheet, what to know when there's something that's not on a rap sheet. There's a clue, as you all know, and the chief knows, motion is not updated. They don't have disposition histories on there. And so what we've discussed with John is that we want to make sure that the people that are giving us recommendations know how to look at a local motion run, know how to call and outline a law enforcement agency to make sure that the guy doesn't have a pending armed robbery in Jefferson Parish, because that arrest history is not going to show up on a local criminal history rap sheet, that whoever's doing this has access to NCIC, so they don't know if the person has something in another jurisdiction out of state. I mean, those are all factors, and John's been very open about listening to our concerns and support, because if the program's to have any type of validity, or if we're not going to be out there making and recommending bonds on bad information or incomplete information, we want to have that all there. So back to my initial point, the person who is going to be running this needs to be somebody that's, you know...
And it sounds like, from what you're saying, that the pretrial services working group is a perfect place for those issues to be fully vetted, because that's exactly precisely what the working group is about. And, you know, I mean, obviously, you got to have somebody who knows what they're doing the program, or else the program's not going to be valid and isn't going to last. So,
I think Councilman Johnson had that question too when we made our presentation to your working group on the council. You know, who's going to be running it? After Vera passes it off, who's going to
yeah,
be?
the DA and I didn't undertake to make that decision. We did state that it's definitely something that needs to be decided. And we assume, I think, that the implementation of this initial program is going to help lead to establishing the answers to those questions.
I think it's really important just for the legitimacy of the group, and just so that we make the right decision, and that the right call is being made by the judicial officer. You know, the whole point of a pretrial services program is to make sure that the judicial officer has enough information to make a correct determination. And I am privileged to be on the working group, and I'm very happy with the way things have been going. Everybody's working together. We all have our differences. We all bring our own points of view to the table. And there's been a really great working relationship in a way to kind of make sure all the issues do get tested and do get vetted. And that's the point of having a good pretrial services program from the very beginning.
Sure.
Along those same lines, Mr. Wu made a comment that this has never been done before here. We've never done anything like this before. And I just wonder if that's really accurate to say that, you know, because I know in the past there have been mechanisms that, you know, as Judge Burris pointed out, that do things like checking someone's criminal background history and you know, so is that a fact, or is that, you know, it's not maybe not done as with as many facets as this one is, you know, like you get a car that has power windows as opposed to hand crank, or has this never been done before here? Because I had a different impression.
I think you're right, and I'll qualify what I said too. In fact, in the sheriff's office, and maybe this is one of the things you're recalling or alluding to, had some years ago what they called the SINPAT program. And they did do, and still do to some extent with select individuals upon request, a look into some of these aspects, mostly focused on criminal history. I think what's important is the comprehensive nature of this, sort of the self-executing nature. If you're arrested, the idea is if you're arrested, there will be a process for every individual who goes to first appearance in the state court system where the same factors that will be ultimately tested to correlate, to prove their correlation to the two safety axes will apply to those individuals. And you'll have a routine process of evaluating the risk of flight and criminal activity if released for every individual who comes before the court. And so the court will have this sort of established as a routine, something that they know for every individual, can compare one individual to the next. So you're right. I didn't mean to say that no inquiry has been or is being done with regard to any of these factors. That's just not the case. The commissioners do make their own ad hoc and sometimes regularized inquiries. This is broader and more systematized and applies across the board. And we will have a much more data-driven evaluation process so that we know, rather than the experience of individual judges and their feelings about what works and what doesn't, we will know what factors are most correlated, and we'll be able to constantly feed back that information. So that's the difference.
And in the same vein, one of the things that you say here, Councilmember, is that the primary factor, this is on that second page in the second paragraph under pretrial services, the primary factor that presently determines whether an individual gets released from OPP is simply his or her ability to post bond. Now, I don't know what the numbers are on, for example, RORs, but I don't know if did you figure that in with this, or are you talking about not the ones that get released on their own recognizance, but those that are left over. Judge, you have any?
I follow what you're saying on that. Yeah, I mean, you know, the interesting thing about this is going to be with the new shift in misdemeanors to municipal court, which isn't up for debate right now, but like previous meetings too. I mean, you know, we talked about this too, what pool is going to be left for pretrial services to deal with, and I think we've been kind of talking through the triaging, whether or not pretrial is going to be dealing with every single arrestee that comes through, or a more focused group that we know may or may not be able to have a bond, an ROR bond or a PSP bond. I don't know if that's kind of.
I think the sheriff's correct as well. I mean, there's a first cut that happens at present, if this is what you're getting at, Sheriff, that judges in, and we're only able to get.
I don't want to belabor it. I was just trying to, because we're talking numbers here, everybody seems to want to get to a number, and I'm trying to focus in on, when you say things like the primary factor, to me that implies a number. I was wondering if you included things like that, you took that into account, or you didn't.
Well, like today I had 9 arraignments on my docket and 7 more on bond. I think only 2 to 3 of my arraignments were in jail. So I think that's an interesting question. You know, there's a presumption that everyone that against whom charges are being accepted are in jail because they can't afford a bond. I don't accept that as a starting premise. I've got no problem with the pretrial. I'm on the group. I like working with it. But so it troubles me as well when I hear those kind of assumptions that only the people that are in jail are those that can't afford a bond, and there are other factors at play there.
And then the other point I wanted to make is the juvenile program, down from 50 a day to 23 a day. But they don't include the 39 that we're housing over at OPP. The juveniles being tried as adults. So I don't know if that was factored in when they had this average daily population at the Youth Study Center up at 50, if they were holding some of those, or if they were less inclined to try them as adults. You follow what I'm saying? Like, in other words, did they have the same number? I don't know. I mean, y'all are looking at all these numbers and this historical data. Did they have the same number of juveniles that were being tried as adults back when the average daily population was 50?
That's a good question. I understand what you're saying. I'm getting that information from juvenile court, but I'll ask them that question.